before a couple of months ago, and we are very happy to have her back again to talk about the developments in the reverse mortgage world for those folks that have their spouse has borrowed money through the use of reverse mortgage or a HECM. Sometimes you might hear that as a HECM. And we now have that spouse who has passed on or has moved out of the house, and the attempt to foreclose on the property with the remaining spouse still in the home trying to save it. So there's some very interesting and new developments going on right now, and I'm very happy to have Sarah with us. So thank you.
Sure, thank you. I'm happy to be with you, and thanks everyone for joining the webinar today. So as Becky mentioned, this is an area where a lot is happening very quickly. So I'm hoping my goal today is to provide you with the latest information that we have about this problem and what HUD seems to be doing about it, and options that you may have if you're representing a widow or widower who was not the borrower on the reverse mortgage. That's really what we're going to focus on today. Of course, there are some other issues related to reverse mortgages that you may see, such as people who default on the property charges, such as the property taxes and homeowners insurance, or other heirs who are trying to deal with the property after the borrower passes away. So if it's not a spouse, this issue is not going to arise, and the strategies we're going to talk about today would not apply. But for many people, there are a large number of spouses who were left off of a reverse mortgage loan, and we're going to explain kind of why that happened and ways that you can handle those cases if you see them come in the door. So just a brief overview of where we're going. First of all, many of you may know that there has been litigation going on around this issue in the DC District Court for several years now, and I'll give you the latest on what's going on with that litigation, which was brought by AARP, co-counseling with the firm of Mary and Scallett. That's the case known as Bennett versus Donovan, and now the name has changed to Plunkett versus Castro, the new Secretary of HUD. We'll then talk about Mortgagee Letter 2015-03, which was issued in January of this year and later rescinded by HUD, and I'll explain a bit about what's going on with that from what we know. And then I'm going to talk about these cases in general and the litigation theories that can be useful if you are representing a spouse who was left off of a reverse mortgage loan and is facing foreclosure. So first of all, just to provide some really brief background, and I'm not going to spend a lot of time on this, I'm sort of presupposing that people have a little bit of familiarity with reverse mortgages, but not a great deal, and I just want to make sure we all have some key terms and understanding to grasp the issue that we're going to be talking about. So first of all, what we're talking about today are FHA insured reverse mortgages, and Becky mentioned the word HECM, and that stands for Home Equity Conversion Mortgage. So if you hear about a HECM, it's a government-insured reverse mortgage loan. And in fact, the vast majority of reverse mortgages that are originated or that ever have been originated are these government-insured loans. There are a very small number of proprietary reverse mortgages that are not under the HECM program, that are just privately made and perhaps sold for securitization, but that don't involve HUD. But the big majority of reverse mortgages that are made are under this program. So it is a government-insured program. And the requirements of the program are, first of all, that the borrower must be at least 62 years old. The way the loans work, of course, is that there is no monthly payment of principal or interest on the loan. Instead, the way a reverse mortgage works, the loan amount is advanced at the beginning, and so that's the initial principal balance. And the interest that's accruing on that balance, plus a servicing fee, is added to the loan balance each month. So the balance on the loan actually goes up over time instead of going down, and that's why we call it a reverse mortgage, as opposed to a forward mortgage, a regular mortgage where you're paying down the balance over time and you're paying the interest that's coming due. So with reverse mortgages, as I mentioned, there is no requirement to make monthly payments of principal and interest, and instead the loan balance just goes up and up over time, and eventually the loan becomes due and payable upon a triggering event, a trigger event. And typically what we're talking about there is death of the borrower or the borrower permanently moving out of the house. That's when the loan becomes due and payable. And so it is possible that the loan balance may grow to eventually exceed the value of the house. And the goal is for that not to happen, and that's in fact, when these loans are made, the amount that the consumer can borrow depends on their age, because HUD has set a sort of a calculation that has to be done that's basically an actuarial calculation, assuming people will live a certain number of years and the home value will go up, roughly 4% average year over year. And so the goal is that the home will appreciate and stay to be worth more than the balance of the loan. But of course, it's possible that you could end up upside down on one of these loans. And that's really why Congress created the HECM program, because to federally insure these loans so that lenders would make them and not worry about the risk of having these deficiencies that they can't recover. And these loans, these HECM loans, are non-recourse loans, which means the lender, if the loan balance does grow to exceed the value of the house, the lender will never come against the borrower or the borrower's estate for any personal liability on that debt. The lender is basically limited to recovering the house itself or the value of the house, and then the government insurance would cover any shortfall. And Congress did make a decision to authorize this program, or to authorize HUD to create the HECM program, out of a policy goal of allowing seniors to access some of the equity in their home at a time when they may be equity rich and cash poor, where they may have reduced income and increased expenses as they age and after they retire. And so the goal of the program was to allow seniors to tap into that equity, but also to prevent displacement from the home and maintain that housing stability. So with a reverse mortgage under the HECM program, as I alluded to, there's an initial calculation of how much the loan will be for, how much the original principal balance will be. And that's based on the appraised value of the house at the time the loan is made, prevailing interest rates, and the age of the youngest borrower. And basically, the older you are, the more you can borrow up front, again, because of that actuarial calculation. So I wanted to show you this equation, and I'm going to walk through these terms one by one, but this is just important for understanding these issues. So when you have a reverse mortgage, we talk about the principal limit, and the principal limit is basically the initial amount that will be loaned, and that will cover any loans that have to be paid off if it's a in a refinancing, any other money out to the borrower, and also the closing costs. So the initial principal limit, how much money the borrower will get, is a factor of this number called the principal limit factor multiplied by the maximum claim amount. And so what is the principal limit factor? Principal limit factor is something that's published by HUD. There's a table of principal limit factors. And again, it depends on the borrower's age, and you do round up to the next year if the birthday is coming up within the next 6 months. So you look at the borrower's age and the expected interest rate, which is a term of art. If it's a fixed rate HECM, then the expected interest rate is the same as the interest rate for the loan. But on an adjustable rate HECM, which many of them are, this number is basically an index tied to a margin. So you figure out the principal limit factor by looking at the age of the borrower and the expected interest rate. And again, the principal limit factor will be lower if the borrower's age is lower, and will be higher if the borrower's age is higher or greater, holding the interest rate constant. The maximum claim amount is the lesser of the appraised value of the house, or this maximum number, which is now $625,500, and that adjusts occasionally for inflation. So basically, when we talk about the maximum claim amount, that is the appraised value of the home at the time the loan is made, but it does cap out at this $625,500. So again, just to jump back to that equation, how much money the borrower will be able to get from the loan is determined by the principal limit factor multiplied by the appraised value of the home, which is also known as the maximum claim amount. So the issue that we're talking about today arose because basically what we're addressing here, the problem of spouses that were left off of reverse mortgage loans that were taken out by their spouse, arose because until very recently, HUD was allowing lenders to extend a reverse mortgage loan to one of two spouses and completely ignore the younger spouse in calculating the principal limit. So essentially, basically what HUD was saying was, if you have a married couple, you can base the loan on just one of the two spouses. And so while that was happening, the loan documents that the lenders were using said that the loan would become due and payable upon the death of the borrower, and it really left the spouse unprotected. And this contradicted the statute that created the HECM program, and I'm going to show you the language of that statute in a moment. But when Congress created this program, again, one of their main goals was to prevent displacement of seniors, to allow them to tap into the equity in their home without the risk of losing their home. And in fact, the statute itself says that no HECM loan should become due and payable until the death of the homeowner and any spouse. But HUD basically ignored that language in the statute and issued regulations that said, even if there's a spouse, you can make a loan to just one out of two married people and ignore the non-borrowing spouse in the calculations. So many younger spouses were left off of reverse mortgages either because they were under 62 years of age, which meant they couldn't qualify to be a borrower on a HECM loan, or because they needed more money from the loan in order to get the loan to close. And this is something I've seen in most of the cases I've looked at, where basically because of the existing mortgage balances that needed to be paid off or some required home repairs that had to be done in order to close the reverse mortgage, they needed as much money as possible. And of course, they would get higher loan proceeds by having just an older borrower and leaving off that younger borrower in order to borrow the maximum amount possible. And of course, unfortunately, there were many loan officers and loan brokers who wanted to get this loan to go through because, of course, they didn't get paid unless the loan closed. And so there's heavy push marketing of these products towards seniors. And oftentimes, the loan officers were encouraging people to take out the loan, even if it meant leaving off a spouse, and did not explain to them the risks or actively misrepresented the risks of doing that by saying things like, oh, your spouse will still be able to live here until she dies, even if she's not a borrower, or we'll just add her when she turns 62. You know, there were a lot of things that people were told, and in most of the cases that I've seen, the vast majority, there was a great deal of misrepresentation by loan officers and misunderstanding on the part of the borrower and the non-borrowing spouse about the implications of doing this. So here is the statutory language that Congress enacted about the HECM program, and it's in a section that's titled Safeguard to Prevent Displacement of Homeowner. And so what it says is that the Secretary of HUD may not insure a HECM under this section unless the mortgage provides that the homeowner's obligation to satisfy the loan is deferred until the homeowner's death, sale of the home, or occurrence of other events that can be specified in the regulations. And it says, for purposes of this subsection, the term homeowner includes the spouse of a homeowner. And why this is important is because when a HECM is taken out, only the borrower can be on title to the home. So you had some spouses where they used to both be on title to the home, and in order to get the loan closed, they would advise the non-borrowing spouse to quit claim over her interest in the home. Because basically the way the program is created, at the time the loan is made, only the borrower or borrowers can be on title. So that's why it uses the term homeowner. But it's very clear here in the statute that the loan cannot come due and payable until the death of the homeowner and any spouse of a homeowner. And I've given you the statutory citation for that. So unfortunately, as I mentioned, HUD issued a regulation that contradicts that statutory language and says the mortgage shall state that the mortgage balance will become due and payable in full if a mortgagor dies and the property is not the principal residence of at least one surviving mortgagor. And of course, the mortgagor is the borrower on the mortgage. And there's the regulation site for that. So essentially, HUD was requiring lenders to, in order to comply with HUD's program, to say that the loan would come due and payable on the death of the borrower, ignoring any spouse who may still be living in the home, even though the statute says that should not happen. And in fact, HUD also created the required loan documents that lenders had to use, the promissory note and security instrument, mortgage or deed of trust, that also both say, per the requirements of HUD, that the loan will become due and payable upon the death of the borrower. Now, because of the litigation that's been going on in DC brought by AARP, HUD has fixed this problem prospectively. So they issued a mortgagee letter 2014-07 that they issued in April of 2014, and it took effect for all new HECM loans originated after August of 2014, August 4th, 2014. So for any HECM originated after that date in August of 2014, even if there is a spouse who is left off, who is not a borrower, the lender has to run the calculations for the loan, factoring in that spouse, and the loan documents state that basically the loan does not become due and payable so if there is a spouse of a borrower still residing in the home. So for new HECMs that are being originated, you should not see this problem anymore. But there are a large number of loans that are out there that were originated from the beginning of the program in late 1980s up until now, up until August 2014, that have this problem. So the reason this becomes a problem is that the lenders have a contract that says they have the right to foreclose once the borrower dies, regardless of whether or not there's a spouse living there. And the lenders are trying to comply with HUD's regulations so that HUD will pay their insurance claim if they have to make a claim on the insurance after they foreclose. And so basically, the HUD has a trigger in their regulation that says that a servicer must initiate the foreclosure promptly after one of these triggering events. In fact, they have to initiate the foreclosure within 6 months of the borrower's death. And if the lender does not follow that timeline and meet that date, HUD will impose what's called interest curtailment. And under interest curtailment, basically HUD is stopping the clock for any interest that may accrue on the loan and saying, because you didn't foreclose timely, any interest that accrues after this date is not going to be covered in the claim if you have to file a claim with HUD. So HUD has these rules in place that says that if a lender doesn't initiate foreclosure promptly after a triggering event, they'll be penalized financially by no longer being insured for the interest that's continuing to accrue. And so that's why, as this problem has been going on, and I'm sure many of you may have seen people come in the door who are facing this problem, you may have a servicer of a reverse mortgage who is moving forward with foreclosure, and many times advocates are saying, stop, you need to stop the foreclosure because HUD is trying to figure out how this problem is going to be fixed, and this widow should not be evicted, it's against the language of the statute. But you have a servicer of a reverse mortgage who feels this tremendous financial pressure to initiate foreclosure. And HUD did grant a number of temporary foreclosure delays over the past year or so while it's been sorting this issue out. And so there was a 60-day stay, and then there was an indefinite stay of foreclosure where HUD said, if there's a spouse, you can delay and we won't penalize you if you ask for one of these extensions. But basically, without HUD creating a final and long-term solution, lenders have been put back in a situation of feeling that they have this time pressure to foreclose, even if in reality they wish HUD would fix this problem. So let me go over the litigation that's been going on in DC and kind of bring everyone up to date on where that stands right now. The initial case that was filed was called Bennett versus Donovan, back when Sean Donovan was the Secretary of HUD. And initially, the district court in DC dismissed the case for lack of standing, said that the plaintiffs did not have standing to bring the suit, and the reason was based on redressability of the harm. And so, of course, for the concept of Article III standing, in order to be a plaintiff in a lawsuit, the plaintiff has to show injury, causation, so that the defendant actually caused the injury, and redressability. And of course, redressability being, can this defendant fix this injury, this harm? And so where the district court initially thought there was a problem was redressability, because they said, even if HUD messed up and caused this problem, now you have these lenders that have an independent contractual right to foreclose, and even if we rule that HUD did something wrong, it can't be fixed by HUD because of these freestanding contractual relationships. So that was the initial district court decision. However, the DC Circuit Court in 2013 overruled that decision and held that, in fact, there was redressability. And the court, in a very short and very powerful opinion, said, yes, HUD does have the ability to fix this problem. For example, HUD could take assignment of the mortgage loans and hold the mortgage loan and basically pay the lender by taking assignment of the loan, essentially buying the loan from the lender, and then HUD could forego foreclosing until that spouse dies. And the court was careful to say, we're not saying HUD has to do that, but there is a way for HUD to fix this problem, and there is enough of a likelihood that HUD could fix this problem to create standing. And in that circuit court ruling, which I highly recommend to you, the court has some great language where basically, even though the question wasn't before the circuit court said, and by the way, I can't believe HUD completely violated the statute here. So even though they didn't reach the question of whether the regulation violated the statute, the court indicated that it certainly looked like this regulation did violate the statute. And so then we have the district court decision from September of 2013, where the court did hold that, in fact, the regulation violated the clear language of the statute and was invalid. However, in that decision, that was not a class action decision. That was basically, the court had not certified a class, and so it was just as to those plaintiffs, but the court did hold that the regulation was invalid as to those plaintiffs, and then remanded the case to HUD to fashion a remedy, to come up with a solution for this problem. And that's the tricky thing about this litigation that's going on in DC. It's been brought under the Administrative Procedures Act, the APA, which is the vehicle for challenging conduct by a federal agency if it fails to comply with the necessary procedures, or if it violates a statute. You can challenge agency action under the APA. But the way that typically works is that a court may rule that, in fact, the agency violated the statute, but then rather than fashioning a remedy itself, the court sends it back to the agency to take the first crack at fixing the problem. And then the court still maintains the ability to review whatever the agency does under the arbitrary and capricious standard. So that was what happened in the litigation when it was going under the name of Bennett. So when the court remanded that to HUD to come up with a solution, we got these two things that are being called the Mortgagee Optional Election, the MOE, and the Hold Election, the HE. So I want to explain what both of these are and how they came about. And I realize this is very dense. It's a lot of material to cover in one webinar, so I hope I'm not moving too quickly. And I am going to stop for questions shortly in a few more slides and sort of make sure that everybody's following what we've covered so far. So the Mortgagee Optional Election was something that HUD created when the court remanded it to HUD to come up with a solution. And essentially, I should say that the litigation changed names from Bennett to Plunkett because there was a new complaint filed as a proposed class action with additional plaintiffs, and then the two cases were consolidated. So now both of those cases are under the name Plunkett versus Castro. And so what HUD did when it was told you've got to come up with a solution for this was it created this Mortgagee Optional Election where the mortgagee, the lender, could elect to assign the loan to HUD. And that, again, they were very clear that that would be a choice. It would be up to the lender. HUD is not forcing any lender to assign a loan to HUD and thinks it doesn't have that power. But in order for a lender to even make the choice to assign one of these loans to HUD, there's a 5-factor test that the loan would have to pass. And one of these 5 factors is something called the principal limit test, which I'm going to talk about more in a moment. But if those 5 factors were satisfied, basically then the creditor would be able to assign the loan to HUD, and HUD would hold the loan and delay foreclosure until the spouse's death. Let me go ahead and talk real briefly about the principal limit test, and then I'm going to come back and talk about the hold election on this slide. So as part of this mortgagee optional election, the MOE, where the lender could elect to assign the loan to HUD, the loan had to meet what was called the principal limit test. And I've given you a link to a previous webinar that NCLC put on where we explain this test in great detail if you want to try to run the numbers. We also have an Excel spreadsheet that I'm happy to provide to people that will let you actually run the calculations, but it's very tricky and very detailed. And for reasons that I'm going to explain in a minute, most people probably don't need to run those numbers right now because HUD is kind of considering what its next steps are going to be. But for the mortgagee optional election that HUD created, basically there were 2 parts to this test, to the principal limit test. The first part was called the principal limit factor test and said the loan passes if the spouse would have had a principal limit factor that is greater than or equal to the principal limit factor of the borrowing spouse. So just hearkening back to the beginning when I was going over some of the vocabulary, remember that the principal limit factor is based on the age of the borrower and the interest rate at the time. So the only way that a non-borrowing spouse would have a principal limit factor greater than or equal to the borrowing spouse would be if the non-borrowing spouse was the same age or older than the borrowing spouse. And that's almost never going to be the case because that's the exact reason why these spouses were left off the loan, was because they were younger and they would have had a lower principal limit factor. You may find a very rare case where they were the same age or the non-borrowing spouse was older and maybe they were left off because it was a recent marriage and they weren't on title to the house at the time or something like that. I've actually seen one of those where they were the same age. But for most people, if they're not a borrower on the reverse mortgage, the very reason is because they were younger. So they're not going to pass part 1 of the test. So there's a second option for passing the principal limit test. Part 2 is the principal limit test part of, and I realize that the names are duplicative, but it's the overarching test is the principal limit test. And in this second part, you look at the actual principal limit instead of the principal limit factor. So the idea here with this second option for passing the test is to do a retroactive analysis, looking back over time, to see what the principal limit of the loan would be now if the spouse had been included in the calculations at the time the loan was made. So again, you're looking back retroactively to say, well, if this younger spouse had been included, first of all, what would the initial principal limit have been at the time based on the spouse's age, if she's younger? And then taking that initial principal limit, you then have to calculate the growth over time, basically the interest that would have accrued on that initial principal limit, and it's compounding monthly. So the actual principal limit, caused the loan to grow over time. Now we're doing this sort of hypothetical calculation to say, if we had had this lower starting point, how would it have grown over time? And is the resulting number that you come up with higher than the current principal balance? If so, you have a problem. If that number is higher, then they pass. But if that number that you arrive at is lower than the principal balance that you have now, then the spouse has to pay down the current principal balance of the loan to get to that number. So what we're saying is for most spouses who were left off the loan, it's because they were younger. If they had been factored into the loan balance today would be lower than it is now. And how much lower depends on a number of things. Depends, did they take out all of the money they were entitled to borrow? How great was the age difference between the spouses? But for most non-borrowing spouses, the principal balance today is a good bit higher than it would have been if they had been factored in. And so the amount of money they would have to come up with to pay down the principal balance would be somewhere between $10,000 and $40,000, or maybe even more than that if it's a large dollar loan, because remember, the interest is growing over time on the existing balance. So this is the principal limit test, and again, recall that this is a required part of the mortgagee optional election that HUD created. That HUD was telling the lenders, you cannot assign the loan to us unless the spouse can pass this test. And for most spouses, it's going to be impossible to pass that test because they were older. I'm sorry, their spouse that borrowed was older than them, and they're not going to have $10,000 or $20,000 laying around to pay down the principal balance. So the other option that came about was something that HUD never formally put forward as an option, but HUD took the position in one of its briefs in the litigation that because the regulation was invalid, because it violated the statute, the foreclosure timelines were not actually triggered for these loans. So that requirement that the lender initiate foreclosure within 6 months did not come into play. And HUD called this the trigger inapplicability decision. And so the court looked at this and said, it looks like even though HUD only formally created one option, the mortgagee optional election, HUD has implicitly acknowledged this other option, which is to say that the lender could just hold on to the loan and not foreclose because the triggers have not actually been triggered. And then the lender would just assign the loan to HUD whenever it reaches 98% of the maximum claim amount or the appraised value of the home. And that's something that lenders can always do. Whenever there's any reverse mortgage outstanding, once the balance reaches 98% of the maximum claim amount, they have the right to assign that loan to HUD at that point. And so this hold election, or it was initially called the trigger inapplicability decision, basically said essentially a lender could just hold on to the loan and not foreclose and eventually later assign it to HUD when it reaches that 98%. So I've walked through the principal limit test. So basically what happened after these two options were created, and again the second one, it was sort of inadvertent that HUD created it, HUD said it was just going to offer the MOE to the Plunkett plaintiffs. And the district court, in a decision in August of 2014, said that the creation of the MOE was not arbitrary and capricious. And of course, that's a very high standard of review. But the court said that was okay. It wasn't arbitrary and capricious for HUD to limit that option by imposing the principal limit test and all those other onerous terms. But the court said that by failing to consider extending the trigger inapplicability decision, or the hold election, to these plaintiffs, that was arbitrary and capricious, because the fact was that HUD talked about this in its briefs, but then didn't formally create a pathway for spouses to go through this hold election where their lender would just hold on to the loan. And so the court said they should have considered that. And in fact, they should have considered it for all non-borrowing spouses. And so this is the weird thing about the Plunkett decision in August of 2014. The court said basically any non-borrowing spouse who's in this situation is the same. There's nothing special about these 6 plaintiffs just because they're part of this lawsuit. So the court remanded it to HUD to consider offering the trigger inapplicability decision, or what's now being called the hold election of holding the loan, to consider extending that to all non-borrowing spouses in this situation. However, the court refused to certify a class action. And still the court, to this day, has never certified a class action in the Plunkett litigation. And that's why seniors around the country are still having these problems. And we're seeing advocates and attorneys who are feeling the need to file individual lawsuits all around the country because the Plunkett court has never certified the class, even though they're talking about this in a sense that makes it clear this issue is the same as to everybody in this situation. So that was what the court said in August of 2014, was that HUD should consider the option of the hold election and should actually consider it for all non-borrowing spouses. And so what came out of that was HUD issued this mortgagee letter 2015-03 in January of this year, where HUD said it was going to extend the mortgagee optional election to all spouses in this situation, but it was not going to extend the hold election to anyone else other than the spouses who had gotten a judgment saying that HUD's regulation was invalid. And that was basically the 6 named plaintiffs in the Plunkett litigation and 1 plaintiff in a case that's been going on in Georgia that I've worked on my Atlanta legal aid time, since I split my time between legal aid and NCLC. So our client here in Georgia had gotten a ruling from a court that the reg was invalid as to her, and so HUD was saying we're only going to extend this hold election to those folks who have already gotten this judicial determination, and for everyone else we're only going to extend the mortgagee optional election. They said we thought about it, the court told us we had to think about it and consider it, and this is the decision that we're making. And HUD did, basically the reason that HUD gave for that was stating that extending the hold election to all surviving spouses would be too costly, would impose a financial risk to the insurance fund that is simply too great. That's what HUD said. And so instead, in this mortgagee letter, HUD basically offered the assignment, the MOE assignment, to lenders and said that lenders had to make the election of whether they wanted to assign the loan within 90 days following the issuance of that letter, or 30 days from the notice of the borrower's death if they hadn't yet been notified. And they did later extend the 90 days to be 120 days. And then HUD said we could give additional extensions of time, but that's in the full discretion of HUD and didn't really indicate when they would give any extensions of time. And so part of the problem is that HUD issued an option that really doesn't work for most people. And then also they imposed these very strict time limits and requirements that many people have had trouble complying with. So what are the requirements for someone when this mortgagee letter was in effect, and as I mentioned, it was later rescinded. I'm going to talk about that in a moment. But when it was in effect, there were these factors that had to be satisfied. The first one, the most problematic one, was the principal limit test. And most people are disqualified on that basis alone and cannot have their loan assigned to HUD under this program. The other thing is that the spouse had to have been legally married to the borrower at the time the loan was made and remained married to the borrower until the borrower's death. Although there is an allowance for same-sex couples who could not legally marry at the time of the loan, but did become legally married before the borrower's death, that they also can satisfy that prong. They also have to show that the home is the spouse's principal residence and has been the whole time since the loan was made. And this is another big one, that the spouse has title to the property or the legal right to remain in the home for the rest of his or her life, or can get that lined up within 90 days of the borrower's death. So the problem is this 90-day time limit, because for many people, they may have to go through the probate process, and it can take longer than 90 days to figure out, getting a will probated or figuring out dealing with an intestate situation. So HUD put in place this rule that says you either have to have a title interest in the property. It wouldn't have to be sole title, but a ownership interest in the property or the right to remain in the home for the rest of your life, which could be done through a long-term lease, presumably, and that has to happen within 90 days of the borrower's death, which could be pretty onerous for people. They also have to show that the loan is not in default for any other reason other than the death of the borrower. So there's no default on the property taxes and homeowners insurance. That one is a common problem because a lot of people who have reverse mortgages, I think it's about 10% of the outstanding reverse mortgage loans, have a default on the property taxes or homeowners insurance. So basically that's an independent basis for a foreclosure. And HUD is saying you've got to be able to bring that current and show that the loan is not in default for any other reason if you want to have your loan assigned to HUD and have the ability to stay in it for the rest of your life. You also have to show that there's no claim that would invalidate the loan. So if you've made a claim that there was fraud in the origination of the loan that convinced this spouse to give up her interest in the property or convinced them to go forward with this, that type of claim would have to be resolved in order for you to take advantage of the MOE assignment. And finally, the balance cannot have gone above the maximum claim amount at the time the loan is assigned. So as of right now, the litigation is still ongoing in DC. There has been a motion to amend the complaint in the Plunkett case. And if it's granted, the name of the case would change again because they've added a new named plaintiff called Solera, who would be the first named plaintiff. And basically, in that proposed amended complaint, they're attacking Mortgagee Letter 2015-03, saying that it is arbitrary and capricious, that for HUD to only create this limited option that doesn't work for anyone, and that HUD should have done something that actually worked. And also attacking the restrictions and requirements that HUD put in place for the hold election, which are basically all of those things I just listed except the principal limit test. So all of these different factors, except for the top one, these other things still apply for the hold elections, and there are still time limits and things like that. So the plaintiffs in Plunkett have also said that there shouldn't be so many restrictions on that. That basically the statute says what it says. It says that you can't insure a loan that doesn't protect the spouse from displacement, and by putting in place all of these onerous requirements, HUD is contradicting that requirement. So what happened was that after basically after this amended complaint, proposed amended complaint was filed, HUD actually withdrew Mortgagee Letter 2015-03, and that was done on April 30th of 2015. We don't know exactly why HUD decided to do that, and the strange thing is, the very same week, HUD had issued a response to all of the public comments that had been filed on the Mortgagee Letter, where HUD was basically defending what it had done and saying, we think this is perfectly fine. Here are some answers to the specific questions that lenders asked. But there were a number of advocates who really challenged this Mortgagee Letter and said, this is ridiculous, you're not helping anyone. And so HUD issued this one document totally defending what it had done, and then 5 days later withdrew the Mortgagee Letter and said, everything is on hold, and HUD issued a 60-day stay of foreclosure. So any spouse who is living in a home where there was a reverse mortgage and the borrower has died, the lender has this option of giving a 60-day delay of foreclosure, and they will not be penalized by HUD. And basically, HUD was indicating that within this 60-day time frame, it will figure out what it's going to do next and issue a new Mortgagee Letter with that policy. And so that 60 days, if you're doing the math, would run by the end of June. So right now, everyone is just waiting and holding our breath to see what HUD is going to do. Some people think that HUD is going to issue basically the same broken policy that does not help anyone, with more justification and maybe slightly clearer guidelines for how it's supposed to work. Other people are cautiously optimistic that maybe HUD has listened to what people are saying and is going to actually issue some new options that might work for people. But we really just don't know at this point. And I skipped over the middle bullet point on this slide. There was another case that was filed in DC called Snyder versus Castro. It's basically, that complaint is the same as the proposed amended complaint in Plunkett. The only difference is that they had 3 clients who were facing immediate foreclosure sales, and they were seeking a TRO to stop those sales. And unfortunately, the court, it's the same judge, Judge Huvel in the DC District Court, denied their motion for TRO on April 23rd, 2015, which kind of made everyone a little depressed about how the court was going to rule on the underlying issues. But then after denying that motion for TRO, again, HUD rescinded the Mortgagee Letter 2015-03 and granted this 60-day stay of foreclosures. So none of those plaintiffs have been foreclosed on, and basically the litigation in both cases is on hold for everyone to wait and see what HUD is going to do next. It was initially stayed until June 1st, and then those cases were also delayed again until July 1st. And the expectation is that HUD will issue a new policy by the end of June. So a few practical concerns and questions that people may have, and then I want to stop and take specific questions or any questions that people have sent in. First of all, people might be wondering, if you knew about this issue before and you knew about the Mortgagee Letter 2015-03, maybe you requested the MOE assignment on behalf of a client, and now that MOE assignment option has been withdrawn, and you're wondering, what do I do now? What can we do? I know that we have several of those cases here in Atlanta where we actually had a few clients who, oddly enough, were able to satisfy the principal limit test because they were within just a year or two in age of the borrower, and the amount they needed to pay down the principal balance was very small. So for those people who asked the lender to elect the MOE, and the lender did, and now it's basically on hold. And it's not clear what will happen, but it is pretty clear that all of the things that had to be finalized after the lender made that election are also on hold, and it would seem that HUD is going to give people a chance to comply with that or do whatever other option once they announce their next steps. The other question you might have is, what if my client is facing a pending foreclosure sale and you're trying to figure out what their options are? What I would say to that is, remember, you have this 60-day stay of foreclosure or delay of foreclosure that's in place right now, and you can tell the servicer, I'm requesting that you take this 60-day stay. We're waiting for HUD to announce what it's going to do. And if you're not getting the right answer from the person you're talking to, it's a good idea to go up the chain at the servicer, talk to someone who's higher up, and we do have a list of contacts that are helpful at the various reverse mortgage servicers, so feel free to reach out to me or Odette Williamson at NCLC. Either of us can help you get in touch with the right person if you're struggling to get a servicer to cancel or postpone a sale date that's pending. Final thing I wanted to mention at this point before stopping to take questions is that HUD claims that the reason it didn't offer the MOE, the reason it only offered the MOE assignment and did not offer the hold election was that it would be too costly to the HECM insurance fund and possibly, bankrupt the fund or create major problems for the fund. But the problem is that HUD has released almost no information about how it came to that conclusion, and many of us are very skeptical about what HUD knows, what kind of research it has done to figure out the scope of the problem. And so in one place, HUD has estimated that the cost of doing the hold election, the one where people just get to stay in the home until they pass away, they've estimated it would be $1.769 billion. And they've based that number on saying that they think about 20% of all of the reverse mortgages out there are impacted by this problem. And that would be about 100,000 loans, because there's just over 500,000 reverse mortgages outstanding right now. And the way HUD reached its number here, they're assuming that all non-borrowing spouses on HECM loans were more than 5 years younger than the borrowing spouse. And we got this from some of the documents that HUD filed in the Plunkett litigation. So HUD is just making this assumption that if people were within 5 years of their spouse's age, they would have been included as a borrower on the loan. And I frankly don't think that makes any sense at all. And of course, by assuming that all of the non-borrowing spouses who were left off were much younger, it drives up the cost of letting them stay until they die. There's another group, NRMLA, the National Reverse Mortgage Lender Association, who has estimated that, in fact, the cost of solving this problem would only be $500 million, $521 million, which I grant you is still a substantial amount of money, but it's a lot less than $1.8 billion. And NRMLA thinks that there are about 12,000 impacted non-borrowing spouses, which is a lot less than 100,000. So the point I'm trying to make here is that HUD says they have very little information about the scope of the problem and, the ages of the non-borrowing spouses, that they don't have all that. And so it seems like they're really spitballing when they come up with these estimates that make it seem that it would be impossible for them to do the right thing. Let me stop there, Becky, and see if we have some questions that I can address at this point.
There's two, actually. One I was just in the middle of trying to answer, but I think I'll just give it to you to answer out loud.
Sure. Okay, sounds good.
The first one, I believe that the question was, has the case been certified? He says if the case has been certified as a class action. And then the second part, of course, that it has not yet been certified, but what would happen to a spouse who filed for bankruptcy protection, started an adversary proceeding against the lender alleging fraud or other defenses?
So I think that's so first of all, it's right what Becky is saying, essentially, that no, there still has not been any class certified in the two lawsuits that are pending in D.C. And we don't know, they continue to renew the motion for class certification, but again, right now that litigation is on hold, and this judge just seems to not want to certify a class. So at this point, that has not happened. So if a spouse chose to file a bankruptcy, perhaps to stop a foreclosure, and file legal claims within the bankruptcy, first of all, I think that's a really good strategy for dealing with these cases. In the second part of the webinar, I'm going to talk a little bit more about litigation strategy if you choose to sue HUD or sue the lender or both. How do you handle that, and how do you keep the foreclosure at bay while you're dealing with it? So doing it in the context of a bankruptcy is a good option because you get the automatic stay to stop any foreclosure that might be pending. And so I think I'm not sure if the question is saying if a class later gets certified, what would happen to that litigation? Is that how you're reading it, Becky?
It's one way to read it. I'm not certain, to be honest.
It's one way. Yeah, so just to address kind of all the options, what I would say is if a class later gets certified, then I think individual plaintiffs would still have the option to opt out of the class. But the good thing is it would address all of the other spouses who are not represented by counsel, because of course there are many people who don't have the ability to file their own lawsuit on this issue. So if a class is later certified, there would be notice and an opportunity to opt out if you want to continue with individual litigation instead of being part of that class. And then of course the other part of the question is talking about fraud claims against the lender. And there are different strategies that you can pursue on these cases. One is to raise those fraud claims against the lender. The other thing is to go after HUD for the fact that HUD issued a regulation that violates the statute. And it's possible to do both. There are some different pros and cons to each, and I'm going to save that and get into that in more detail in the next part of our time together. So I'll stop there.
Okay. So the next question, let me pause and offer just a little tidbit at the end of it first. So the question is, are there any protections in the statute for family members of the borrower other than the surviving spouse? And let me just add that at the very beginning, Sarah mentioned that this is just related to surviving spouses. However, there are very specific protections that are offered essentially through the foreclosure process, what the lender must do in order to foreclose, and they have to give some alerts and some notifications to folks. But we do have other webinars that we have offered that have been recorded and is in our HOPP portal on the Empire Justice Center website that you can, this information has been covered in some previous webinars that the specifics of that question can be viewed again in the recorded webinar. So let me then turn it over to the actual expert.
That's really good. So then I'll keep my answer brief and just say, and as Becky refers you to those other resources, I think that's right. And what I'll say is, what we're covering today, the statutory protection was for spouses. And so if you have other family members or heirs who are living in the home or want to try to save the home from foreclosure, they're not going to have the option of making these spouse-related arguments. The main option that becomes available is the possibility of satisfying the loan by paying 95% of the appraised value of the house. Because normally, when a reverse mortgage becomes due and payable, if the heirs want to avoid foreclosure, they have to pay off the loan, either by selling the house or by refinancing, or if they happen to have a lot of life insurance proceeds lying around, whatever means, but they have to satisfy the entire loan. They can't keep the loan in place. And so normally they would have to pay the full balance of the loan, but there's this other option that you can pay either the full balance, or if the balance has grown to exceed the value of the house, the heirs can satisfy the loan by paying 95% of the current appraised value of the house. So you might have an heir client who has the ability to qualify for a forward mortgage, a regular mortgage loan that would essentially pay off this loan by paying 95% of the appraised value of the house. That's the main option to think about, but I'll just let you look at those other resources for more information.
Okay, perfect. And I think that that's it for now.
Okay, so we'll keep going. And so now what I want to do is talk a little bit about, let's say someone has come into your office facing this problem and you're trying to figure out, what should I do now? And first of all, I hope we're all going to have more information by the end of June, and maybe, fingers crossed, maybe HUD is going to issue a policy that actually helps people and that it will work so that you don't have to sue HUD. But up until now, that hasn't happened, and I was really surprised when HUD rescinded the mortgagee letter at the end of April. Up until that point, what I had been saying to people was that if you can't satisfy the principal limit test, you might have to sue HUD to try to get the hold election. Because as I said, basically what HUD had done up until the end of April was to say everybody gets the MOE, but the MOE requires you to satisfy this principal limit test that most people cannot satisfy. But HUD had said that if you get a judgment against HUD declaring that HUD's regulation is invalid as to your client, then HUD will offer the lender this other option, which is the one you need, where your client gets to stay in the house until she dies, provided that she can do these other things. And remember that for any of these cases, it's likely you're still going to have to deal with those other factors if you're trying to help someone who's remaining in the home. First of all, you're going to have to show that they were married at the time of the loan, again with that exception for people who were same-sex couples that were unable to marry in that state, but that they were married and stayed married until the borrower's death, and that they can obtain title to the home or the right to stay in the home until this client of yours passes away. And finally, the big one, that there's no other default, that the taxes and insurance are current on the home or can be brought current. So be aware if somebody comes into your office and you see that the taxes and insurance are, $8,000 past due, and this person doesn't have any ability to bring that current or any ability to make those payments going forward, that might not be a case where you can keep the person in this home. They have to be able to afford the ongoing taxes and insurance, because if they can't make those payments, that's a totally independent basis for foreclosure. And so there are some folks who maybe just can't afford to stay in the home. But if they can satisfy the taxes and insurance and they're current now or can be brought current, then the possibility of suing HUD and maybe also the lender could result in getting a solution that would allow your client to stay in the home for the rest of his or her life. I say her because oftentimes it is a widow because they were likely to be younger and to live longer. So many of these clients are widows, but some of them are widowers. So in that case, you might consider bringing a variety of legal claims. The big one is the claim under the Administrative Procedures Act, the APA. I'm going to talk about that in a bit more detail. Then there's also the possibility of a claim for reformation of the contract or breach of contract, and then claims for fraud or misrepresentation. So APA claims, I'm not going to spend too much time on this because I want to try to get through as many of these as possible and still save some more time for questions. But first of all, as I sort of already talked about, HUD's regulation and the fact that the regulation violated the HECM authorizing statute. And that's the crux of the APA claim, is that because the regulation violated the statute, the regulation is invalid. And then you take that a step further and say that because the regulation is invalid, there is no due and payable event. There is no triggering event that requires the lender to foreclose. And HUD has actually said that that's the case and has said that, the fact that the regulation invalid creates this automatic result that the triggers should not actually kick in. But HUD has only recognized that as to the named plaintiffs who have actually gotten a judgment to that effect. And so typically, and I will say that in our case that we litigated in Georgia, we actually had filed a motion for TRO asking the court to enjoin a foreclosure. The court denied our motion for TRO, basically because they said, well, the lender still has the right to foreclose even if HUD did something wrong. So I'll talk about that problem a little bit more at the end. But the judge said verbally on the record, however, I find that this regulation violates the statute and is invalid. And on that basis, shortly thereafter, HUD offered the lender the hold election for our client. So that's what the goal would be if you file an APA claim. Now, there's one very important thing I have to point out. This might be the most important thing I'm going to cover in the whole webinar, and I'm sorry I didn't get this onto the slide, but it's something that I had realized very recently at the last minute. So the important point to note here is that HUD took the position that when they issued Mortgagee Letter 2015-03, that Mortgagee letter actually replaced the regulation in several key ways. And HUD took the position that instead of the regulation imposing foreclosure triggers, now the Mortgagee letter takes its place, and it's the lender's decision whether or not to elect the MOE that actually then triggers the foreclosure timelines. So there's actually a case that I've cited a little bit later. I'll point it out to you, but it's called Bombet, B-O-M-B-E-T, out of Louisiana, where HUD made this argument that basically even if the reg is invalid, it doesn't matter because we've replaced the reg with this other thing, this mortgagee letter. So you need to know about that. You know, for right now, HUD has rescinded the mortgagee letter. So you have this unique moment in time where, once again, it would appear that the invalid reg is in place, and you could challenge the reg right now, and you know, it wouldn't be moot or there wouldn't be any problem. But eventually, HUD may issue another mortgagee letter that it says is taking the place of the regulation. So the key thing is that if you fashion an APA claim, you need to attack both the regulation and any mortgagee letter that HUD issues that purports to deal with this problem. You have to attack both of them as violating the statute, because if you only attack the regulation and HUD comes back and says that reg is not even in effect anymore because we fixed it with this mortgagee letter, then your argument is going to be moot, basically, at that point. So for right now, there is no mortgagee letter in place because it's been withdrawn. If you're filing a lawsuit now in the next 20 days, you're probably fine just attacking the reg, but you've got to stay tuned and figure out if HUD issues another problematic mortgagee letter, you need to include that in your attack. Okay. Just another word about the APA claims is you can take this argument a little bit further. And by the way, if anyone decides to file a lawsuit for these types of issues, we have sample pleadings that we're happy to provide. You don't have to reinvent the wheel. We've all been sharing pleadings back and forth who have been litigating these cases. So please feel free to reach out if you want a template or a place to start. But what we argue under the APA claim is that because there has not been a due and payable event, there has not been any real triggering event because that trigger was invalid, then there's also no basis for HUD to pay an insurance claim if the lender chooses to go on ahead and foreclose, because the regulation is the contract of insurance. The statute and the reg together is the contract of insurance between HUD and the lender. There's no other contract. Basically, the terms of insurance are in the statute and the reg. And so you can argue that if the lender forecloses, they actually should not be able to make a claim on the insurance. That's an important argument to make to change their incentives. And you would then argue, but still HUD is still obligated to compensate the lender. They have to make the lender whole. And the way for HUD to do that is to take immediate assignment of the loan so that the lender can get paid but not have to foreclose. So if you raise an APA claim, there are a number of defenses that the lender might raise. The big one is standing. And so what the lender and HUD may say is that regardless of what HUD did wrong, the lender has this independent contractual right to foreclose under the loan documents. So any relief that you would get against HUD is not going to fix your problem. And the lender might also argue that the spouse doesn't have any standing to interfere with their contract with HUD. So I would just refer you, the bad decision on this is the Bombit case, here it is, that I mentioned from Louisiana, that basically said there was no standing because of Mortgagee Letter 2015-03. And as I mentioned, that Mortgagee Letter now has been rescinded, so at this moment in time I would say that decision is not applicable. But it's also on appeal. There is an appeal that has been filed. The briefing schedule is, I think the briefs are due in July, so it's, I hope the Fifth Circuit will straighten that out because it's a very bad decision, unfortunately, in the Bombit case. But the other place to look for good language about standing is the Bennett Circuit Court decision and the Plunkett decision from August of 2014. Both have good language about standing, and I gave you the full citation for those in an earlier slide. So I think there are very good arguments about standing, but the issue is likely to come up, and what you need to know is that the probability of relief or a likelihood of HUD being able to afford relief is enough to confer standing on your plaintiff. Mootness is a similar argument that may be raised, and the way this could come up would be if HUD said this is moot because we've already addressed the problem by issuing a new mortgagee letter that, let's say, they may issue at the end of June. And so, of course, whether something is moot is a factor of whether your plaintiff has this personal stake in the outcome of the case. And if they lose that personal stake, then the court may say that the challenge is moot. There is some discussion of this in the Plunkett decision from August of 2014. But what I would argue is, at least for right now, the issues are definitely not moot because the mortgagee letter has been rescinded. And if there's a new mortgagee letter that gets reissued that says the same things or things that are equally unhelpful, you would say it's not moot because, first of all, I think that what HUD has done is arbitrary and capricious and still violates the statute, and that basically it's not moot as to this plaintiff because the outcome for this plaintiff will be different if I get a ruling saying that the HUD regulation and mortgagee letter are invalid. So what you're going for with an APA claim is a declaration that the reg and perhaps any mortgagee letter that's issued are invalid. And then, of course, the court will remand it to HUD to fashion appropriate relief. The courts generally on these APA claims have taken this position that they can't order the agency to take a particular action. So that's the tricky thing here. But often in most of these cases, once the court has said that the regulation is invalid, then HUD seems to be doing the right thing by offering your client a way to stay in the home until he or she passes away. The next claim I want to talk about a little bit is breach of contract. So you may also want to make an argument that there's a breach of the insurance contract here. And so the way this works, this is a little tricky, but there is the argument you would make is that there's a three-party contract of insurance, and the parties to that contract are the borrower, the lender, and HUD. And you have to argue that the spouse, the non-borrowing spouse, is an intended third-party beneficiary, because obviously the spouse was not the borrower and was not a party to the contract itself, but you would argue that they're an intended beneficiary. And so, as I mentioned, the insurance policy is actually defined by the statute and regulations. There is no other insurance contract or binder. And so you would argue that this insurance contract actually includes the spousal protection in the HECM statute. And that's what makes it clear that your client is an intended beneficiary, because the language of the statute says that spouses are protected from foreclosure. So you would be arguing that HUD and the lender have breached the insurance contract by attempting to allow a foreclosure to go through without protecting the spouse from foreclosure. And so the important thing to reference here is take a look at paragraph 17 of the mortgage or deed of trust that actually specifically says the instrument is governed by federal law. That's kind of a helpful provision, and also mentions severability, that if there's any provision of the contract that violates federal law, it can be severed from the contract. So that's a helpful thing to point to. I did just want to mention briefly that I heard about a case from North Carolina where both spouses actually signed the mortgage or deed of trust, even though only the borrowing spouse signed the promissory note. If you see that fact pattern, you have a very good case for breach of contract, because the mortgage or deed of trust will actually say that the due and payable, that the loan does not become due and payable until the death of the borrower. And if your spouse is included as a borrower in that mortgage document, you have a really good argument that there's no right to accelerate or foreclose. I think that's going to be pretty rare, but if you see it, it's always a good option to just look for that. Defenses that a lender may raise to a breach of contract claim would be that, first of all, this borrower is not a party. They may argue that the borrower was not a party to the insurance contract, that it was just a contract between HUD and the lender. But of course, there are benefits to the borrower from that insurance, and the borrower is the one actually paying the insurance premium. So I think there's a good argument that the borrower was a party to the contract. And then, of course, you also may have a fight over whether or not the spouse is a third-party beneficiary. There are some difficult cases that say there's a presumption against third-party beneficiaries for government contracts. Many people have seen these in the context of HAMP, trying to enforce HAMP contracts. But it's important to point out that in this context, the insurance contract is specific as to each loan. Spouses are specifically identified. And so I think there are good arguments for this to be an intended beneficiary, and we have briefed this issue. So again, if you do litigate these cases, feel free to reach out. We're happy to talk through these issues in more detail. The lender may also argue that the spousal protection only imposes an obligation on HUD and not on the lender itself. But I think you can argue that essentially HUD and the lender both have an obligation to make sure the contract is complied with, and that the lender should be involved in the lawsuit even if the relief you're really seeking is from HUD, because the lender's rights are going to be affected. Reformation of the contract, this argument is slightly different. So instead of focusing on the contract of insurance, the reformation claim is focused on the mortgage contract itself. And the argument you would make here is that there was a mistake of law, and you've got to double check New York law on whether mistake of law is a basis for reformation in New York. I don't actually know that for sure. But under the mistake of law argument, you would say that the parties intended for the loan to be eligible for HUD insurance and to comply with the statute, but by mutual mistake, the loan documents, the loan contract, in fact, did not comply with those requirements. So you want to reform the contract to actually comply with federal law, which was the party's intent. And if you don't have the option of arguing mistake of law, you can argue mistake of fact. And I believe in just about all jurisdictions, that is a basis. Mutual mistake of fact can be a basis for reformation of a contract. And basically it's just saying, again, the parties intended for the loan not to become due and payable until the death of the borrower and any non-borrowing spouse. But by mutual mistake, the contract didn't express that intent. And you're asking the court to reform the contract. Defenses, again, you may have a standing issue where the lender may argue the spouse is not an intended third-party beneficiary. One option here to deal with that would be to have the spouse get appointed as a representative of the borrower's estate. Usually, I don't think that's necessary, and I would hate to cause you the trouble of going to that trouble, but it's one way to get another standing argument as a backup option. Because if your client is the representative of the estate, they also stand in the shoes of the borrower for enforcing the borrower's rights. You may also have a factual issue where the lender likely has documents that were signed by the non-borrowing spouse indicating that she understood the way this worked and understood that the loan would come due and payable upon the borrower's death. And I'll show you here an example of this from one of our cases. I'm sorry, it's a little small, it might not be easy to read, but the part that's highlighted in yellow says, in addition, I understand and acknowledge that should my spouse predecease me or fail to occupy the home where I reside as the principal residence, unless another means of repayment is obtained, the home where I reside may need to be sold to repay the reverse mortgage. I understand that I may be required to move from my residence. And so both the non-borrower spouse and the borrower were required to sign this type of statement after a certain date. It looks like this case was in 2006. So at some point, lenders started using these forms and having people sign them. And so that's going to be an issue with your reformation claim. The lender may argue, no, there was no mistake of fact. Everybody understood what was going on here. And that's just going to be a factual issue that you have to contend with. Of course, many times people sign things without understanding and when they're being told something that totally conflicts. Fraud or misrepresentation claims, the basic argument here is this would be a claim against the original lender for the fraudulent misrepresentations that were made to convince both spouses that it would be okay to leave off the younger spouse. And there were a lot of these misrepresentations made where, they were told that, the non-borrowing spouse will be able to stay in the home, or she'll be added when she turns 62. And of course, it doesn't work that way, that you're going to have to refinance to add her, and they may or may not be able to do that when she turns 62. So there were a lot of misrepresentations made, and you could certainly go after those claims against the original lender. And then, of course, you're going to need to also raise them against the assignee or the holder of the loan now. So this type of claim is not really against HUD, but it's against the original lender and the downstream owner of the loan. Of course, be aware that as I just showed you this document, they may have something like this in the file that says, I fully understand what I'm doing. And so that type of disclosure document that your client may have signed could prove to be problematic, and don't be surprised if they surface those type of documents. But it still may be worth making these arguments and pursuing these claims. Be aware, though, the last bullet point is just a caveat that if you're trying at the same time to get HUD to give your client the hold election, any claim that would invalidate the loan, such as a claim for fraud against the lender, would have to be resolved in favor of the lender before HUD will give you the hold election. And so that means basically dismissing the claim with prejudice. And it's unfortunate, but HUD is requiring people to do that. But of course, you can still pursue these options simultaneously. And then if you get to the point where you're getting the hold election, at that stage, you could choose to dismiss the claim with prejudice in order to get the hold election. A couple quick strategy issues, and I do want to save a few minutes, for at least 5 minutes, for questions at the end. But I wanted to raise a few of these things. The first issue is, where do you raise these claims? New York, I understand, is a judicial foreclosure state. So if the lender files for foreclosure against your client, or files for foreclosure, you're going to have this question. I think in many judicial foreclosure states, there's a temptation to say, can I do this as a counterclaim in the foreclosure, and then bring in HUD as a third-party defendant? And so, and of course, there are many reasons to do that. It may be lower cost. As I mentioned here, if you affirmatively sue HUD and the lender in federal court, you're going to have to pay a new filing fee, and you're going to want to seek an injunction to stop the foreclosure from going forward. So there are plenty of good reasons to want to try to do it in the foreclosure case. The problem is you may have a sovereign immunity problem if you do that. So remember that if you're suing an entity of the government, there's a general concept of sovereign immunity unless it has been waived. And there is a waiver of sovereign immunity for APA claims that are brought in federal court. And I've given you the statute. It's 5 U.S.C. 702. There's a good case out of New Jersey, that Bank of Elizabeth versus Gonzalez, that really explains it. But what it's saying is HUD has only waived its sovereign immunity to be sued on APA claims in federal court, not in state court. There's one other possible waiver of sovereign immunity that you could look at, and that's under the National Housing Act, which this part of it actually says that the Secretary shall, in carrying out provisions of this subchapter, be authorized to sue and be sued in any court of competent jurisdiction. And the National Housing Act does include the HECM statute. And so one court I'm aware of did discuss this as the possibility of bringing a breach of contract claim or an equitable claim under the National Housing Act, as saying that HUD's carrying out of the HECM program was the problem. But in that same New Jersey case, the court said this does not authorize a claim for judicial review of agency actions, like an APA claim. And so it seems like the National Housing Act only gets you the right to bring certain types of claims in state court, but your APA claims still may have a problem. I am aware of at least one case where HUD chose not to raise that argument and allowed the case to proceed in state court, but I think that's really risky, because even if HUD doesn't raise it, subject matter jurisdiction is really not waivable. The court can raise it sua sponte, or you could end up getting a judgment that you later find out is worthless. And even if HUD removes the case to federal district court and doesn't raise this argument, just brings it to the district court court's jurisdiction is derivative from whatever jurisdiction the state court had. So I think the bottom line of what I'm trying to get across here is the safest thing is to bring this as a separate claim in federal court, as opposed to including it as a counterclaim in state court. You can certainly read these cases for yourself and make your own decision, but I think there's a risk on the sovereign immunity issue. And then just be aware that if you're raising a breach of contract claim, anything that's for less than $10,000, the jurisdiction is exclusively with the U.S. Court of Federal Claims, and that's under the Tucker Act. So if you're raising a claim for damages, you want to make sure you plead more than $10,000 in damages to keep it in your district. Or the main ball of wax in these cases is really injunctive relief. So you might not really be focused on damages. Keep in mind that one thing that you're thinking about in these cases is whether to sue just HUD or to sue HUD and the lender. My general advice is to include the lender as a party. I think there's a good argument that they're a necessary party under Rule 19, because even though HUD is the one that's really done wrong and that you need to correct the problem, the lender's rights are going to be impacted, and it's helpful to have them participating. And keep in mind that in however you raise this claim, you're trying to stop the foreclosure sale from going forward. And it can be a little difficult getting a TRO or preliminary injunction to stop a foreclosure sale, because contractually the creditor has a mortgage contract that says they have the right to foreclose based on this death of the borrower, regardless of any spouse. The problem is that violates the statute. So the important thing if you're seeking an injunction to stop a sale is to focus on HUD. And even though the court may have a concern about ordering HUD to take a particular action, there is this section of the APA that explains that the court can compel agency action that's been unreasonably delayed, and I've given you the site for that, and focus on maintaining the status quo and preventing irreparable harm. Obviously, those are key arguments when you're seeking an injunction, and to basically try to make the language of what you're seeking in your TRO as narrow as it can be. So you're focused on HUD, and you want the court to order HUD to allow the lender to not foreclose, and basically order HUD to say that it will not impose interest curtailment, that it will not penalize the lender for not foreclosing, or order HUD to send a letter to the lender explaining that it's not going to curtail the interest. And there is a good case out of a trial court in California. I've given you the name and the basic citation. If you need the order, as I don't think it's on Westlaw, I'm happy to send it to anyone who needs it. But that court in Hill versus Generation Mortgage did grant a TRO to stop a foreclosure sale. And I've given you some sample language that you might consider using if you're seeking injunctive relief. I won't dwell on that. Someone asked a question earlier about the possibility of filing bankruptcy. That is a great backup option for stopping a foreclosure. And I just wanted to point out to you that even though your client was not a borrower on this loan, if your client is an owner of the home, even if she's not the sole owner, but if she has an ownership interest in the home that vested at the time of the borrower's death, then her filing of a Chapter 13 bankruptcy will stop a foreclosure sale from going forward. And it would be treated as a claim in her bankruptcy case, even though she doesn't have personal liability, just because it's a debt that is secured by her home. And so I've given you some good citations for that. Of course, the tricky thing is she's not going to be able to cure the default in her bankruptcy. So the filing of a bankruptcy would have to go hand in hand with litigating these underlying issues, because obviously she's not going to be able, in most cases, they're not going to be able to pay off the loan through the bankruptcy plan, and it has been accelerated at that point. I think I've already kind of covered this, but again, I would recommend that you include the lender as a party in addition to HUD. I think it's helpful to have them involved. However, keep in mind that the attorney's fees that the lender accrues, they will add to the loan balance. They will attempt to do that. So just keep an eye on 98% of the maximum claim amount, because once it gets to that point, once it gets above the maximum claim amount, HUD will not accept assignment of a reverse mortgage. So you need to kind of ask the lender about that and make sure everyone's keeping an eye on that if you do include the lender as a defendant. I think the remaining slides are really just wrap-up points, so I think I'll stop there for now and see, Becky, if there are other questions that we should take, and if there aren't many, I'll come back and go through these slides, but the rest is pretty self-explanatory. So let me see if there's any questions.
So it's actually just a follow-up statement by the same gentleman that asked the bankruptcy question before. So he just clarifies and says, but in bankruptcy, the spouse could cure any defaults, such as real estate taxes, in order to qualify for the HUD relief, which in New York, taxes are a major issue for many folks.
I'm sure they are. I bet the taxes are pretty high in New York. So the only thing I would say is I think it's a really good point to remind people that in general, when there's a reverse mortgage default on taxes and insurance, bankruptcy can be a helpful tool to cure that kind of default. The problem that you may have if you have a surviving spouse and you're trying to do that is, so far, HUD, when they issued their mortgagee letter 2015-03, they were saying all of these restrictions had to be met within a very quick time frame. Basically, the lender had to elect the option within 90 days, and then I think there were 90 more days to complete all of the criteria. So HUD would have taken the position under that mortgagee letter that you could not use the bankruptcy to cure the T&I default, taxes and insurance default, because you had to do it within the 90 days in order to have the loan assigned to HUD. But again, we're sort of waiting to see what HUD is going to issue next. Maybe they will be more flexible on the timing. but you could have a problem if you're planning to use a bankruptcy to cure a default on taxes or insurance, because HUD seems to be bent on requiring certain criteria to be met quickly. So you may have to challenge HUD's decision to do that.
And that's the only question we have at the moment.
Okay, so let me take 2 more minutes and just run through these other slides. So I just wanted to point out that when you're litigating these cases, again, the primary goal is to get a judgment that says the regulation is invalid, and keep in mind also here any subsequent mortgagee letter that HUD may issue, perhaps in the month of June, addressing this issue. And of course, I should say it's possible HUD will take more time and give itself another extension, but we think they're going to issue something by the end of June. Discovery is likely not going to be very important in these cases because it's really an issue of law, whether the regulation is invalid or not. Most of the arguments you're making are legal arguments, unless you're getting into fraud and other issues. And so the goal is to get HUD to offer the creditor the hold election and then get the creditor to take the hold election, which most of them seem very willing to do because they're pretty financially indifferent. Many of these creditors actually don't want to foreclose on little old ladies, and if they have a way of getting paid without doing that, they seem to be happy to do that. And in the case that we litigated, the lender was very cooperative and actually bent over backwards to meet all of the criteria so that she could take the hold election. And so that's what you're shooting for often in these cases. I just wanted to mention that it's possible to recover attorney's fees for claims under the APA, and I've given you the citations here. In the Bennett litigation, they did recover attorney's fees. In our case, we're currently negotiating that issue with HUD, so we don't yet know if we're going to reach an agreement or if we're going to have to file a motion on the issue, but that may be helpful for people to know. I think I addressed these practical concerns already at the beginning, but just keep in mind that if there's a default on taxes and insurance, you may need to try to cure that promptly. And you also want to think about, is the home habitable? Does the spouse want to stay in the home? And is there going to be a probate problem, or can she establish her right to stay in the home? I already mentioned the option to refinance and pay off the loan at 95% of the fair market value. So just keep in mind that you may have a spouse, if the home is worth very little, maybe this works better than trying to qualify for one of these options. And a spouse can do this just like any other heir, is to satisfy the loan for 95% of the current fair market value. Also, I would just mention that these cases, until HUD says they're going to do the right thing, it's very important to sound the alarm and tell your story if your clients are willing to do that. So please consider reaching out and being part of efforts that are going on. NCLC is engaged in ongoing efforts, and there's a lot of interest in this problem right now. And I think I'll stop there.
I think that's it for the moment. We don't have any more questions. You want any closing thoughts, Sarah, while people write their questions in?
I guess I would just say I really hope people are on the lookout for these cases, and feel free to reach out to NCLC if you have one. They're very tricky. I know we conveyed a ton of information in this session, so if you've got someone and you're thinking about how to draft a complaint or wanting to check and see whether your client could satisfy the principal limit test, if in fact that gets reissued, as it may get reissued, please feel free to reach out to us.
And I'll add a plug. I haven't reached out directly on reverse mortgage issues, but certainly when I was dealing with TILA and some convoluted HOPA claims that I was trying to put together, reaching out to the folks at NCLC has always been quite the life raft for me when I was clearly in over my head at moments. And I would just strongly encourage people to reach out if you would like some assistance just figuring out who the right person is. You're always welcome to give me a call, and I can try to find the right person for you. But again, I would like to reiterate that Sarah did offer some sample pleadings. So just like we have in New York, we have Pro Bono Net. NCLC does typically offer some assistance with some of those types of requests as well, depending on the issue. And I don't see any other additional questions. So perhaps it's one of those things where once the case crosses your desk, that's when the questions arise. Sarah, this presentation, just like the last one, was incredibly thorough and easy to understand and follow, and I really appreciate your time and efforts on putting this all together. So thank you, Sarah, and thank you, everybody else around the state. Have a good day. Oh, I
Thanks
lied.
very
One
much.
more thing. I'm so sorry. There's a couple more things. Just some tidying up and housekeeping issues. We do have the CLE verification code in the chat box, and I'll read it out loud. It's capital J, capital A, 22Y, as in yak. And for those of you who are listening in with somebody else and you're both using one computer, you don't have to have been registered in order to get that CLE confirmation and certification or a certificate of attendance. Just simply send that off to Michelle and she can get you what you need. And then one more thing, the next webinar that we will be hosting will be taking place in July. Oh shoot, I just had it up, I'm so sorry. July 15th, right?
Yeah.
Oh, I had it up and I think I closed it in an attempt to clean up my little screen here. Give me one more second. Here it is. It'll be the statute of limitations in residential foreclosure actions. So as many of you are aware, some of these zombie kind of foreclosures are coming up to the surface, and using this as a tool is going to be quite effective for some of these cases. So stay tuned. It'll be an hour long, at least we anticipate it'll be an hour long